Thank you, Chair. Thank you, organizers, for a kind invitation. Dear ladies and gentlemen, this is the final section of this year's conference, at least that's good news. And it will be about consequences of Brexit for EU social security coordination. So let me start with the observation that the United Kingdom of Great Britain and Northern Ireland, so UK, has always believed in the importance of European integration. Already in 1946, just after the Second World War, Winston Churchill, at that time Prime Minister of UK, gave a speech at the University of Zurich, emphasizing the importance of some sort of United States of Europe, leading by strong Germany and strong France, and the material strength of a single state should be less important, and small nations will count as much as large ones, and so on. That the structure of some kind of United States of Europe will fit well in the United Nations structure. And the question is, did he believe that UK would be part of that United States of Europe? That is the question, because he saw United Kingdom only as being a sponsor and a friend to United Europe, as it should be the mighty America and the Soviet Russia next to the UK and their Commonwealth of Nations. So such belief was more or less fostered also during the membership of the United Kingdom in the European Union, with many exceptions and opt-out possibilities. And it was partially also the reason for a leave vote, as you know, on the 23rd of June 2016, there was a referendum, and with a tight majority, the leave from the European Union was voted for. Now, what is believed that the principle of supremacy never sat very well or fit very well into the UK mind and position, which is, of course, at core of the European Union. And it is argued that 90% of UK legislation is being influenced by the European Union, and the politician says that the European Union did not put Britain at the heart of Europe, but Europe in the heart of the UK, which you see the influence and the relation towards the European Union. So the question is whether United Kingdom was ever politically and psychologically part of EU, or more an island apart, figuratively and actually speaking. And some argue that this debate or such questions are not new or not novel. They were already part of the debate in the 18th century of the rise and fall of the First British Empire. Now, there is a desire to fight supremacy, fight supremacy in a sort and regain sovereignty. So in the Brexit debate, if you follow it in the United Kingdom, they say that the Great Repeal Bill should convert the Union acquis into the UK law. So nothing, it's emphasized, nothing will change on the Brexit day. Of course, nothing will change that day. The problem is what will change after that day. It is argued or emphasized that the representatives of Britain should have their say, and it's even more emphasized not just by the Prime Minister May, but also David Davis, Secretary of State for exiting the European Union, that Britain should take back control, bringing powers back from Brussels, and the UK Parliament should be sovereign again, and UK courts will have the final say. So I think that the problem within the relations between UK and European Union was the question of supremacy, but also migration, which is also in the center of debate on the future politics of the United Kingdom. It was coupled by refugee crisis in 2016, but also free movement from other member states. And you could hear from David Cameron actually saying that free movement should be less free. And he was thinking of, and there is a new expression, I never knew about it until I went to UK and had the discussion also on Brexit, that is, they have a notion of A8 nationals. Have you heard about it? So A8 is not A8 Autobahn or A8 motorway in France, but it's I believe, accession nationals, but from 8 countries, not 10, because in 2004, on 1st of May, 10 new countries joined the European Union. There were mainly Eastern European countries, but also Cyprus and Malta. And A8 should be those 10 countries without Cyprus and Malta. So, okay. But at the same time, being from one of that countries, I have to say A8 is not A8, so it's not everything the same. So the less you know, the more the same it is. The more you know, the less the same it is. Okay? For instance, Slovenia, it was never part of East or West Bloc. We made friends with African states rather, and so have a sneak peek of the both sides of the Iron Curtain and so on. So the more you know, the more you know that there are differences. But it's more political talk. So it's argued that record levels of long-term net migration in the UK put pressure on public services, schools, infrastructure, and so on. And the UK would like to control immigration again and get rid more or less of the Free Movement Directive or Citizens Directive or Citizens' Rights Directive or Residence Directive, so this Directive 2004-38, which has been discussed in detail already yesterday, has different names. So the presentation will focus on social security entitlements. It should be stated that social security is also understood quite differently in different member states, also in the UK, because sometimes, also in the UK, NHS is not being considered part of social security, so National Health Service is usually apart from social security. And in some countries you have social assistance, or in international law even you have social assistance which is outside of social security, or it's being differently treated. So we will take into account the entire social security as the protection provided by the state in case of loss of income or increased costs through some kind of solidarity. And there is also the distinction between Anglo-Saxon definition of a state and more continental Europe of a state, because we have in continental Europe the social nature of the state, especially emphasized here in Germany, Sozialstaatsprinzip, Article 20 and 28 of the German Constitution, and the Constitutional Court of Germany has very much developed that sentence. I think it's also in the preamble of the French Constitution, not being so much developed, but still it's there. And the continental states are, so to say, a normative social state, so the legislator has to do something to regulate the social relations. Whereas the United Kingdom is relying more on welfare state. If you read English literature, they will not speak about social state, they will speak about welfare benefits and welfare state, where priority is given to the family, to NGOs, to informal actors, and the state only provides more or less the minimum, and everything else should be left to the market. So in any case, being social state or welfare state, I think social rights have to be provided, because only social rights can provide social peace. And if you want social peace, so justice has to be cultivated. Civis pacem quale justitiam, as it's the saying of the International Labour Organization, as opposing to civis pacem para bellum. So if you want peace, prepare for war, which we also are witnessing in the present day, how many deals with selling arms are being concluded in the world. So the points of discussion for today will be mainly 3. So one is history of the United Kingdom in the European Union, some attempts to persuade the United Kingdom to remain in the European Union, which, by the way, are already backfiring to other member states, and possible relations and social rights after the day of Brexit, which is 29th of March 2019, if nothing changes. Well, I will go rather quickly through the history because I think it's well known. The membership of UK was vetoed by de Gaulle in France in 1963, and then only 10 years later they joined. And that had consequence also for Ireland and Denmark. They argued that they are so connected that if UK cannot join, then Ireland and Denmark will not join either. And Norway was also the candidate in 1963, but then had referendums that they voted not to join the European Union, so Norway never joined. So it was the first enlargement of the European Union at that time. UK was signatory of the Single European Act, who already had some importance for social rights, living and working conditions, health and safety at work, and so on. But it was the only country which did not sign, I don't think it was really ratified, but it was adhered, in a sense, to the Community Charter of the Fundamental Social Rights of Workers. In point 10, you also have social security and social assistance mentioned. And then UK opted out for the social chapter, which was annexed to the Maastricht Treaty, because the countries could not agree to put it in the treaty. It was just annexed, and we had a kind of two-tier system. But then, under the Labour government of, I think, Tony Blair, agreed to be part of the Treaty of Amsterdam without different consequences, so a two-tier system was merged into one-tier system. And there is, of course, the story of extending Social Security coordination regulations to third country nationals, where these three countries who joined in 1973 had the opt-in and opt-out options. And for the first bridging regulations, for the regulation 1408-71, UK opted in, Ireland and Denmark opted out. For the new regulation, you know, we have 883, 2004, and third country nationals are not mentioned again because it's a different legal basis, and then another bridging regulation had to be passed, and it was 1231 in 2010. Ireland again opted in, Denmark again opted out, but now the UK changed his mind. So UK is now out. So you see the swinging policy, or more reluctant policy towards migration, and especially third country nationals. What does it mean? Does it mean that Social Security regulations are not applicable in UK for third country nationals? I don't think so. I think the first one, so the 1408-71, remains applicable, but not the new one, so which makes the situation even more interesting, not to say complicated. So there's an overview of opt-outs, and you see the United Kingdom has the most opt-outs. It's not in Schengen, it's not in European Monetary Union, Common Development Policy, Area of Freedom, Security and Justice, and Charter of Fundamental Rights. I think with Poland they had an opting out, and the special protocol was passed. About EU competence, you know that there is exclusive competence of EU or the national states, and their shared competence. And that is about Social Security coordination, which should be at its core. So Social Security coordination's purpose is to enable free movement of persons. At first, workers, then self-employed family members, and also non-active citizens. As you know, with the Treaty of Lisbon, the provisions of Social Security coordination were modified. So not every country has a veto, because now we have qualified majority voting, but the right to veto was modified. So if the country does not recognize the proposition of the Commission, then the decision of the European Council can be demanded, and then the European Council decides by unanimity again. So the right to a veto was just modified, but it means that the member states have less control, including the United Kingdom, which was, I think, also important for them. It is unifying national law, so we have regulation, which is a unifying measure, but not the substance, of course, but the formal part is unified in all member states. It should be applied uniformly. You know that cross-border healthcare has become even more interesting, not to say complicated, with the case law of the Court of Justice and the cross-border healthcare directive. We should not call it patient mobility directive, because I've learned that you don't need to be a patient to be mobile, and you can be mobile first and then be a patient. We have rules on pensions, especially healthcare for pensioners is interesting. If you're receiving pension from one country or two countries and reside in one, or two countries and you don't reside in one, paying pension, and so on. And family benefits, which we have discussed, and it's quite an interesting topic. Now, going to more interesting thing, it's about family benefits and the attempts to persuade UK to remain in the European Union. We have heard that there is a plethora of family benefits. You have child benefits, child raising benefits. Some family benefits could be linked to invalidity. Some family benefits could be linked to social assistance. Some family benefits could be linked to taxation law, because in many countries you have taxation reductions for family, but in UK, tax child credit is being coordinated. In some other countries, tax law is not being coordinated, and so on. And what is even more interesting, you have entitling, entitled, and receiving person. So entitling person would be a child, because family benefits are received because of a child. Entitled person could be one of the parents, for instance, and receiving person could be the other parent, or a person taking care of a child. You know the Slanina case, where the father did not want to apply for family benefits in Austria, then the mother from Greece could apply, and receive family benefits for a child. Equality of treatment is the main principle. Now, equality of treatment of who? Of children or of workers? And the court decided that it should be equality of treatment of workers. So if you work in a country, pay contributions and taxes normally in that country, you should be entitled to all family benefits regardless where your children reside. And that was confirmed in the first Pina case and in Mahaimo case as well. Now, the hot topic in UK was export of family benefits. And there were numbers how many family benefits have to be exported to other countries, mainly to Poland, but also to other countries. But export of family benefits could be a misleading notion because family benefits are usually not paid directly to the family in another country. They're paid to the worker in the country where the work is performed, and then maybe he pays benefits to or provides something to children or not. So export of family benefits should be understood in a broader sense, so paying family benefits for children who do not reside in the country of work. And there was an argument that export does not allow for proper policy aims, that family benefits, as we heard today, also are linked to families in a specific country, and family benefits should be indexed. Okay. Now, according to Annex 5 to the so-called Brexit agreement, the conclusion of the Council in February 2016, it said that changes to Social Security coordination regulation should be made, and the changes should give member states with regard to exportation of child benefits to a member state other than where the worker resides, an option to index such benefits under the conditions of the member state where the child resides, and standard of living and level of child benefits should be taken into account. Now, there are some problems with that definition, or that promise, which never took place actually because there was a leave vote, not a remain vote. The agreement would be applicable only if the remain vote would be achieved at the referendum. One thing is, in coordination regulations, we speak about family benefits. Now it's about child benefits. Is it just one basic child benefit? Is it one? Is it more? We have child benefits. And it's also different in all languages if you compare different languages of the Brexit agreement. And then, should the worker's residence be decisive? Because it's not the country where you work anymore, it's the worker's residence. Okay, so what about frontier and seasonal workers, as it was the case in Hujinsk and Varzhniak? People were not residing, there were seasonal workers and frontier workers not residing in Germany in that cases. And they were entitled to family benefits. And will that not put pressure on the family reunification? So if the worker has to reside and family members will be entitled to reduced family benefits if they don't reside with him, so they would have to reside with him to receive full family benefits. So that would also be the pressure that was the argument at the time. And of course, the question of indexation of or adjustment of family benefits. So which rules should be taken into account? Some argue that we have some differentiations in staff regulations. But is it that indexation is fully compatible with the treaties? Because that was the case in Pina case. And the court said, no, it's not compatible with the treaties. We already have decisions on that. So is that now okay? Is it the agreement with UK that, and it specifically says, it's in line with the treaties. Okay, so, but who is to decide? Probably the court. Will it be both ways? So downwards and upwards indexation. So for instance, if a worker has family working in the UK, has family in Poland, then UK could have an option to reduce family benefits because the standard of living in Poland is lower. But what about vice versa? What if a person works in Poland and has children in the UK? Should they get more family benefits? If that would be the rule. But if it's only an option to index, so what will happen? The family benefits will just be reduced. So from high-income countries to lower-income countries. But as mentioned, that agreement never came into effect. But indexation as such is not off the table. You have heard the Commission representative yesterday saying indexation is not part of the Commission proposal, which is all well and fine. But you should know also that there is a very strong discussion in some member states, especially in Austria to index family benefits, and they're pushing quite hard, also local politicians, heads of Länder. And there is a strong opposition from some member states, especially from Hungary. I think they're arguing they will lose like 30 million euro, and Slovenia will be affected by 7 million euro. There are already calculations how that would affect families with children, of course. The other question is about social assistance. There's another attempt to persuade UK to remain, which we have already discussed. And the distinction used to be clear. So social security is coordinated, social assistance was part of social advantage according to the regulation 1612-68 or now 492-2011. And then there was a mixture. I mean, in national law, it was always clear that we have general social assistance and categorical social assistance. Just for coordination purposes, it used to be clear. And now we have the directive, the residence directive, and some problems with categorical social assistance, which we have extensively discussed, and especially the case Commission versus UK was an attempt to persuade the UK to remain because it was passed or published just a couple of weeks before the referendum. But again, this case can backfire as well. We have heard, if there is no proportionality anymore, will it be not just for social assistance, but also for other social security benefits? Although I'm not convinced that it will be, because family benefits are also sometimes linked to social assistance. They are provided to a community, to a family, and maybe other benefits will be out of that. But we will see what the court will say. And as mentioned in the case Tolly, I think the proportionality for sickness benefits is clearly mentioned. Now, what will happen after Brexit? And Brexit already has consequences. For instance, Germany, if I'm correct, is issuing only temporary A1 forms. So until the 29th of March 2019. Is that in line with the Social Security Coordination Regulation? I'm not sure, because Article 12 says anticipated duration of work is decisive, and the regulation applies also in the UK. And we don't know whether the regulation will cease to apply on the 29th of March 2019. Maybe it will still apply, depending on the agreement. Or maybe the period of 2 years will be prolonged, because you need qualified majority vote to have an agreement, but you need unanimity vote to prolong that agreement. Okay, so maybe unanimity will be reached and the agreement or the period of negotiations will be prolonged. So we don't know it. Now, the question, what will happen after the Brexit? Well, we don't know. We can anticipate, we can try to find a solution or try to find what will happen. It would be best if agreement would be reached, of course, in containing some sort of free movement of workers and other persons. But it's also a possibility that no agreement will be reached. Okay? Because there is clearly, Theresa May said, no deal for Britain is better than a bad deal for Britain. So it might as well be that there will be no agreement. Okay? So what will happen? Migrants will have to rely purely on national law, because we still have national law also dealing with cross-border situations. For instance, many member states have rules in their legislation. What will happen if a person moves to another country? What will happen with the pension? What will happen with healthcare maybe? And they will be reimbursed some kind of at least urgent healthcare. So UK citizens will probably have to be treated as third country nationals, as well will European Union citizens will be treated in the UK. And the question is, what about legal expectations? Because there were periods of affiliation or contribution before Brexit. So will the regulation remain applicable for periods before Brexit? Because we have discussed today what happened with periods before the country entered the European Union. And we had cases like Röhnfeld for periods before movement before the regulation applied in the member state. We have the case of Tevenon for periods after movement, and after movement the regulation should prevail. And it's also stated in Article 8 of the current regulation, so that the regulation replaces bilateral agreements, and bilateral agreements can still be applicable. Now, what will happen in reverse? So if the country leaves the European Union, so will the regulation remain applicable for the periods of movement before exit or not? So if that would be the case, then the regulation could still be applicable for 30 or 40 years for persons who have moved before. What about vested rights? So already acquired rights. Will pensions be no longer exported? Or will the healthcare no longer be provided in another member state and goes for citizens of UK in another EU member state or member state citizens of in UK? I think both, if legal expectations and about vested rights will have to be one way or another agreed upon what will happen in the future. Now, there are some specific questions. The most vivid debate in the UK is healthcare of pensioners, because there are many pensioners, as you know, from UK, particularly in Spain, and what will happen with them. And there is a more or less serious debate in the UK, because if all the migrants, also from A8 countries, will have to move from UK to other countries of Europe or have their home country, they will lose workforce, and NHS already has problem because of that. And all the pensioners for Spain will have to return to UK. Okay. Now, they will probably not be able anymore to use the European Health Insurance Card, but maybe they will meet the affiliation conditions to be affiliated in the Spanish social security system, if they are residents. But then we're again at the question of residency. If they're residents, they will be probably covered after a certain period of time. Exporting of pensions is another question. Will they be able to export pensions wherever they go or not? And cross-border healthcare from and to United Kingdom. I think United Kingdom is benefiting very much from the provisions as they stand now. Because, as you see also from the case law of the Court of Justice of the European Union, UK citizens or German citizens don't go to be treated in Romania or Bulgaria, but it's vice versa. So Romanians and Bulgarians and other people from other countries go to be treated in France, Germany, and United Kingdom. And especially with the cross-border healthcare directive, you have to pay for services. So they benefit from doctors coming from other countries, but also from services being provided in the UK. Well, will that stop, or will there other provisions be in place? And again, the similar questions with family benefits. And what I've heard is the problem of uninterrupted residence period. Because in order to be resident in the UK and to have full rights, you have to be uninterrupted resident for, I think, 5 years. And nobody thought of that. You know, you became unemployed, you registered as unemployed, but you didn't thought of claiming also the resident rights, because if you're unemployed, you could claim continuous uninterrupted residence. But nobody cared, because there's European Union law. And now it's being slightly too late, because it's less than 2 years. So you cannot build 5 years in less than 2 years, which is another problem. Now, the future. Will we have to rely on bilateral and multilateral social security agreements? The question is, will the old and sometimes outdated bilateral agreements become applicable again? Because they were never repealed. As I said, the coordination regulation just replaces bilateral agreements. Now, if there is no coordination regulation, maybe these old agreements will be revived again. And I know there's quite some old agreements. I mean, there's an agreement between UK and Yugoslavia, former Yugoslavia, from 1958, which is quite an old agreement. And these old agreements have deficiencies. They're closed in personal scope, only for nationals. They might not take into account the insurance periods in third countries. Aggregation for pensions is sometimes agreed only to open entitlement, not the entire period. Healthcare is sometimes, in bilateral agreements, is agreed only to be entitled to urgent healthcare, and in some states also at most urgent healthcare. So not entire range of healthcare. So will new bilateral agreements have to be concluded? Could the European Union conclude one bilateral agreement with United Kingdom, it could be, well, the case, and it could be part of the Brexit agreement in a sense. That would be probably the most advantageous. Of course, there are advantages of bilateral agreements. If you have two states, then they're tailored to the social security systems of two states, but there are, of course, huge disadvantages because it's only two states and the pattern of movements have changed. You just don't go anymore from Italy to Belgium to be in a mine for 30 years. You move from different countries quite often. So bilateral agreements, at least in the European Union or in Europe, cannot achieve their goal. Now, what will be the agreement like? We don't know. There are different models. There is a Norwegian model, so-called soft Brexit. You know that Norway is part of the European Economic Area. There is a EFTA Surveillance Authority, which is doing some control, and EFTA Court as well. There is free movement. Norway is in Schengen zone, although it does not have to be, but does not apply EU citizenship and concludes their own agreements with third countries. But this model is questionable if it would suit the UK because they don't want free movement. Now then is the Swiss option, which is a bilateral agreement. There is free movement of persons agreed, but not citizenship as such. And there is a guillotine clause in a sense. You have, I think, 7 agreements, and if one agreement, one of them being free movement of persons, is terminated, then all others agreements are terminated as well. Okay. So such guillotine clause for the UK? Probably not. There was a recent vote against mass immigration, I think, in Switzerland, and there are already consequences of that vote. The European Union does not allow, I think, Switzerland to be part of Horizon 2020 projects, and Erasmus Plus has been cut, so there are already consequences of that, by the way. The Greenland is a specific case because, you know, the Greenland is the only country to have left the European Union, but it's very specific because Greenland nationals are Danish nationals, actually, then Greenland nationality, and they are, by this sense, also European Union nationals, and Greenland is part of overseas countries and territories. Now, the question is, could it be Brexit as Greenland in reverse? You know, part of Denmark going out, would it be possible that part of UK stays in, like Scotland? I don't think so, because there was clear indication that European Union will negotiate as one and United Kingdom will negotiate as one, and what happens later, happens later. Now there are other examples, agreements with Turkey, World Trade Organization, Canada, we have some agreements. Okay. Now, I think that UK will leave European Union. I think that elections they have on the 8th of June will not change much. I mean, maybe the government will be with different weight, but elections as such change nothing considering the referendum. The referendum is there, and they should go forward with that probably. The question is also whether Article 50 can be frozen, which article regulating the exit of the member state. Because if you know, the Iceland wanted to join. They lodged an application for membership and then frozen it. They were in a bad situation, they tried to be members and then not. Can UK do the same? So ask for exit, but then froze it? That's the question. So the question is whether the process is reversible or irreversible. And some politicians in UK argue that it's irreversible. It's begun and it should be ended. But the person who wrote that article, it's also UK national, I think, he said, no, it was never meant like that. It would also be reversible, so we can also stop it at any time. Okay, we'll see what happens. So even if UK will leave European Union, will UK also leave Europe? I always thought, no, it's not possible. But then I read some articles, and also the Prime Minister is saying, yeah, Council of Europe, it's okay, human rights are okay, but we don't like the court. It's messing with our law, and we would transfer all the European Convention on Human Rights, but we don't want to be under the scrutiny of the European Court of Human Rights. But if the European Convention on Human Rights would still be applicable as interpreted by the court, then I think at least one question would be solved. It's exportability of pensions. Because in the case Pishkur, the court already argued, it was Ukrainian German court, that the pension should be exported. And the ILO Convention 102 is outdated and old, and today with the transferring of money is no problem. So at least within the Council of Europe member states, which are 47 member states, as you know, pensions should be exported. And now the national courts should adopt that argument of the European Court of Human Rights. United Kingdom has ratified the initial European Social Charter without collective complaint procedure, and the European Social Charter also promotes unilateral measures. So in Article 12, paragraph 4, you have coordination, and it should be bilateral, multilateral, and unilateral, and other measures which could be unilateral. So UK could decide and export pensions all over Europe or the world. It would be fully in line with the European Social Charter. And it's always argued by the European Committee of Social Rights that there is no conformity with Article 12 if there is no network of bilateral agreements between member states of the Council of Europe. So that's an incentive to conclude new bilateral agreements. United Kingdom has ratified interim agreements and European Convention on Social and Medical Assistance, which not many member states have. I think many Council of Europe member states ratified both interim agreements, but not so many European Convention on Social and Medical Assistance. But also, the UK has not ratified European Convention on Social Security, which is also a coordination instrument. It's a model convention and in part directly applicable. Now, even if UK would leave the European Union and Europe, it would probably not leave the globe, the world. There are still international social security coordination instruments like those by the ILO, and there was only one that was ratified by the United Kingdom. It is Convention number 19 on the equality of treatment, so only one principle, equality of treatment, and only one scheme, accidents at work compensation scheme, very old convention. So no others were ratified, like 48, 118, 157. 157 is being the most advanced one, but there is an advantage and a drawback to it. If you have the very complicated and advanced coordination mechanism, not many countries want to be bound by it. So Convention 157 was ratified only by four countries, and I'm pretty sure you never guess which 4 countries that are. It's Spain, Sweden, Philippines, and Kyrgyzstan. So only if a person moves between those countries, not within the European Union because we have regulation, but with those countries that convention would be applicable. That brings me to conclusions. As we have seen, European Union-UK relations have always been specific, not very easygoing all the time. And there are many challenges for social security of migrants, mobile persons, and so far we have always found a way to deal with them. I'm pretty optimistic that there will be some kind of agreement or some kind of solution that we can fall back with proper transition periods. Although the standard of persons moving between European Union and UK might not be the same. There is not the same standard between persons moving within European Union, but if we fall back on very old bilateral agreements, that standard could be really low for persons moving between European Union and UK. So, thank you.